States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Okay, good evening, and thank you for attending the Board of Selectmen meeting of February 12th, 2020. On the agenda this evening, we only have, one action item, and that is to confirm and clarify actions taken at the February 3rd, 2020 Board of Selectmen meeting pertaining to proposed host community agreements with 253 Organic LLC, Caregiver Patient Connection, and Heal Sturbridge, Inc., for the resale sale of marijuana, and to a proposed amendment to the existing host community agreement with Heal, Inc. for a medical marijuana facility. Votes may be taken and prior votes may be reconsidered. Before we begin, I do have a few comments I'd like to read just to maybe bring a little clarification to things. And pardon my voice, it always seems to go at 6 o'clock at night. Okay. As many of you are aware, the board's prior meeting on February 3rd, the board considered and voted on proposed host community agreements submitted by 253 Organic LLC, Caregiver Patient Connection LLC, and Heal Sturbridge, Inc., to operate recreational marijuana facilities in the town. As you also know, the final form of the proposed agreements, as submitted to the board at that evening, were the results of considerable time and effort expended by the applicants, the town administrator and his staff, town council, and this board, discussing and refining the terms of the proposed agreements so that they could be presented to this board for its final review and vote. Those agreements and thoughtful discussion by this board on the merits and potential impacts of the respective agreements, the board voted to enter into the agreements submitted by 253 Organic and Heal Sturbridge, and voted not to enter into an agreement with Caregiver Patient Connection. Okay, and I'd like to thank the board for all their thoughtful discussion. Following the votes on the three agreements, and after the applicants and town council had left the room, Selectman Supranant made a motion to reconsider the board's vote on the motion to approve an agreement for 253 Organic. The meeting was paused so that the town staff could locate representatives of the applicants and town council and advise them of the motion before the board. 253 Organic and Caregiver Patient Connection were located and returned to the meeting, but the town was unable to contact Heal, but I understand they watched it on their phones. When the meeting resumed, the board voted to reconsider its motion to enter into the agreement with 253 Organic, and then voted not to enter into that agreement. The board then voted to enter into the agreement with Caregiver Patient Connection. No change was made to the original vote concerning the agreement with Heal Sturbridge. Following the meeting, the board received a letter from legal counsel for 253 Organic expressing their concerns regarding the results of the February 3rd meeting and asserting that there were technical deficiencies in the vote for reconsideration. Selectman Kabinski conveyed to me his concern, and there was significant confusion with respect to the reconsideration votes by the board at the February 3rd meeting, and expressed his further concern as to whether the board followed proper procedures in taking those votes. As I expressed at the meeting, in my opinion, the motions for reconsideration, although I presume they were made with the best of intentions and the public's interest in mind, were ill-timed, and together with comments made by the board on those motions, cast doubt on whether the careful consideration the board gave the proposed agreements prior to the initial votes was based upon a full understanding of the relevant issues. Because of the concerns expressed by the applicant and Selectman Kabinski, concerns that I share and which I believe are shared by our residents, I call this meeting to allow the board to renew its review of the proposed agreements and its previous votes with all interested parties present to satisfy itself that it has all the information necessary to make a full and informed decision on each agreement, to confirm and clarify the basis for its prior votes as it sees fit, and to take such further votes concerning those agreements as it deems appropriate. I have conferred with town council, and he has concurred that holding such a meeting and taking such further votes as the board deems appropriate is within the board's legal authority and would be in the town's best interest. I want to emphasize before we begin that the purpose of this meeting is not to correct alleged procedural errors the board made at the February 3rd hearing. Town council has reviewed the video recording of the February 3rd meeting and has advised that while the board's procedure with respect to the reconsideration votes taken may not have been strictly in accordance with the rules of parliamentary procedure, it is his opinion that the board's procedure was lawful and does not require correction. It has been the general practice of this board to follow Robert's Rules of Order with respect to procedure, but as town council has advised, the board is not bound by those rules or any other rules of procedure that the board has adopted, and the chair may allow deviation from accepted procedural rules and otherwise conduct the meetings of the board in the manner she determines is best suited to accomplishing the board's purposes. Okay, now the way we will conduct this meeting is first I will allow each of the applicants to make a brief statement of no more than 3 minutes in length, summarizing their proposal and addressing the board on the issue of reconsideration of votes as they feel is appropriate. I may allow further comments in my discretion, but in my opinion, the terms and the merits of the respective applications have already been fully vetted, and the primary purpose of this meeting is to allow the board to address any questions and concerns it may have regarding the results of the February 3rd meeting, and to take such further action with respect to the proposed agreements as it feels is appropriate. Second, we will open the floor to the board to discuss the 3 proposed agreements separately or together, and what further actions the board may wish to take, if any. Through the chair, the board may request further information from the applicants as needed. I will accept discussion and a straw vote on the number of agreements the board is willing to enter into, but I will not accept a motion on whether the board is willing to enter into 2 or more agreements. Third, following discussion, I recommend and will accept a separate motion for reconsideration on each agreement. This will allow the board to first determine if it wishes to revisit its prior vote and to confirm or clarify as necessary the reason for each member's vote. I will accept such a motion and second from any board member, regardless of, how they voted previously. If a vote to reconsider is successful, I will then accept a motion to approve the agreement in question. I will treat that motion as the motion being reconsidered, regardless of the form of the original motion, and a vote on that motion will supersede all previous votes to approve or disapprove the agreement. As advised by town council, the prior votes of the board remain valid until reconsidered, and the board is not legally required to reconsider its prior votes. The purpose of this meeting is to give the board the opportunity to clarify, confirm, and reconsider prior votes at its discretion. Should further votes be taken, I request that each board member provide the reasons for their votes as they did in the first meeting, so that the board can make a clear and complete record of the basis for its decisions. Now, the board has a copy of this, don't they?
Yes.
Okay, so you have a copy of the motions, right? Okay, so we'll start with the first step by allowing the applicants to make a brief statement. In no particular order, but
I'm sorry, I don't think I have that in front of me. In my mailbox. Am I just not seeing it?
It wasn't in your packet. It was emailed to you earlier in the...
Okay, I've been gone the entire day.
Wasn't in your packet.
Okay, where in my packet, Andrea? Like, is it below the
Yes, one of those.
threatened lawsuit?
No,
No, the,
It's behind your
and your
agenda.
agenda.
yeah, in the agenda packet.
Should have been.
Okay, I took everything that was in my,
Did you,
okay.
the
Here.
stuff you picked up this afternoon?
I didn't, yeah, I picked it up, then I didn't see it.
That's okay. You can have mine.
Yeah.
Okay, well, I'll take that.
Well,
That's
it's the same thing. No,
Okay.
that's Jeff's.
Thank you.
He now has Andrea's. Okay, in no particular order, but according to the way they're sitting, caregivers, I see you up front. Would you? Good evening.
Hi, Catherine Trifilo, caregiver patient connection. Our proposed property is at 365 Main Street by Friendly's. This is obviously going to be quick. We wanted to thank the board for the opportunity to meet with you again, and we do appreciate the time and effort that has gone into this. We understand that it has been a lot of extra work for the town and the administrator and town planner, and of course, all the due diligence that you've done about all the entities. So we really do appreciate it. We understand that you have 3 qualified applicants, and we also understand that it's probably a tough decision for you. We do appreciate all you've done, and we appreciate the opportunity to consider working with the town in a positive manner. So I hope that you will still consider us for the host community agreement, and I'll leave it over to Dean.
Because I drew the short straw. I guess yesterday when we got the email from Mr. Bridges about speaking to you for a few minutes, you know, we sat down and we talked, and I usually I'm not at a shortage for words, but I didn't really know what else we could say that we haven't, you know, talked about here. You know, I thought, well, we can revisit our location, but we've talked about it and all the positive characteristics that it has, and you know, you know this town and the logistics and the mechanics far better than we do, but we still feel strongly that after listening to, you know, many of the comments made by the board and certainly Chief Ford, that we stand by. We believe 365 logistically is a good fit. I guess if I were to speak to anything, there'd really be 2 things. Speed and relationships, because the first one's come up over and over again in these meetings, and I've heard it about, you know, how fast someone can open. You know, as a kind of a point of reference, last week at the Cannabis Control Commission's meeting, we were voted for our final license for our Fitchburg retail location. So we're going to be open in 30 days. We're really diligent at applications in this process. We submitted our first application last February. It takes that long. So regardless of who's awarded HCA's, there's really no clear time advantage whether you have a vacant piece of property, a building that needs to be rehabilitated, or a fully built building. The clock starts ticking when you hit submit. Personally, I've got the application ready to go. It's simply one document, and then it goes in, the clock starts. It's still going to be 11 to 14 months, no matter what anybody tells you. The other part of this is I think sometimes that you get lost in this whole process, and then the entity walks out of this building with an HCA, and the relationship stops there. And actually, that's very much not the case. It's actually the opposite in a way. The relationship starts there. I find I'm on the phone with the mayor's office in Fitchburg now once every 2 weeks, and getting more often as we get closer to opening. There's communication with Chief Martineau up there. You know, there's communication with the planning department. The relationship continues on. It's our goal to create something really special at that site, and there's going to be a lot of people with ideas on that. And as we move forward, you know, we've made it a point as a company to maintain very open lines of communication, you know, with professionalism, and we intend to continue to do that. So, thank you.
Okay, thank you.
Thank you very much.
Thank you.
I saw you skip seats, Seth, but, oh, sorry. Well, it's still Heel Sturbridge Inc.
Good evening.
Good evening.
I've addressed this board many times before, but for the record, my name is Catherine Browker Adams. I'm here as Heel's attorney. We're joined tonight by Michael McDermott of Dane Torpy, a new addition to Heel's legal team, along with Trish Foss and Jim Bonacorsi, several of Heel's founders. Thank you for this opportunity to address you again. I want to respect the process and the fact that this evening we've been given 3 minutes to present. Due to that limitation, I don't want to spend a lot of time on the fact that General Law, Chapter 34, Section 3, protects Heel as an establishment licensed since 2017, and the fact that Chapter 31 of Sturbridge's zoning bylaw requires the submission of an executed HCA in order to apply for a special permit. So the withholding of an HCA by the board could run counter to the statutory protections afforded to Heel at the state level. I also don't want to review again the delays which have plagued Heel's cultivation facility and stalled the opening of its medical dispensary. Heel's building in Sturbridge is complete. You've all had the chance to view it, and he will be able to operate under an adult use license as soon as the state is able to process it. And finally, I don't want to spend my time this evening responded to the unfounded, unprofessional, and gratuitous comments which were made by one of Heel's competitors after we left the meeting last week. Instead, I want to take this opportunity to thank you for selecting Heel for an HCA last week, and for the recognition with that vote of Heel's protected status, a vote which was consistent with the approach taken by other municipalities, such as Salem, in awarding HCAs where one or more of the applicants is in a protected group. That vote was also consistent with the terms of Heel's medical HCA, which calls for a renegotiation at such time as Heel seeks to convert to adult use sales. Our offer to refrain from recreational sales for a period of 5 years relied on our mutual intent and understanding that Heel would eventually be awarded one of the town's HCAs once it had the opportunity to adopt the appropriate zoning. And we designed our facility in reliance upon this implied promise by making it appropriate for both uses, medical as well as adult use. Your vote last week also recognized that Heel's facility will have the least potential for adverse impact of all the proposed facilities. We'll have the smallest footprint at 1,600 square feet and 6 point-of-sale stations. We've agreed to the 600 customer per day appointment only limitation, and frankly, I doubt that we will even see that volume of customers on a daily basis. The facility is located in the Sturbridge Business Park, right on Route 20, close to the Brimfield Town Line, and there will be little, if any, potential traffic impact on residential neighborhoods, as demonstrated by our traffic study. The parking facility at the site was designed in contemplation of Heel's eventual expansion into the adult use market. We have 27 dedicated parking spaces, and if necessary, the ability to expand up into the upper office parking lot. And finally, we've agreed to refrain from the sale of certain products, including baked goods and ice cream, in response to the board's expressed concerns. When we designed this facility, we were a pioneer and subject to very rigorous and exacting standards as Sturbridge began to carefully navigate the process of permitting these businesses. Our design reflects the input of the police and fire departments, the Board of Selectmen, the Planning Board, and the Design Review Commission in an effort to introduce a new important industry in a way that respects the surrounding established community. For example, we actually installed over 2,000 individual plants around our building in response to requests from certain members of the Planning Board, and we're very proud of the way the building looks. The fact that Heel is not yet operational should not be viewed as detrimental to its potential to operate a safe and well-run adult use dispensary here in town. Heel has a long history of working carefully with this board, and I hope has earned its trust. We've done everything the town has asked of it. We've made payments to the town pursuant to the medical HCA. We've honored our commitment not to seek to apply for adult use until the moratorium that we had is lifted. And the fact that the cultivation facility is not yet operational doesn't mean that we're not well posed to take advantage of the opportunity to engage in retail sales. Hill was founded by a group of Massachusetts residents who've been working tirelessly in this industry for 4 years. Hill has developed supply relationships with a number of other companies and will be able to acquire safe, tested products from those groups as it works to complete its cultivation facility. And our proposed HCA demonstrates Hill's commitment to the community of Sturbridge and our plan to be a sustainable, active corporate citizen of Sturbridge. So I thank you for this opportunity to address you, and I hope that the board sees fit to leave the vote in place this evening.
Okay, thank you.
Thank you.
Okay, 253.
Surprise.
Okay, good evening.
Good evening, Madam Chair and members of the board. Thank you for the opportunity to speak with you tonight. I'm joined by Seth Rutherford from 253 Organic and my partner, Adam Fine. My name is Valerio Romano. I'm a partner with the law firm of Vicente Cederberg. We're a national law firm that only does cannabis policy, licensing, land use, and corporate compliance, that type of work. I'm the land use chair for our firm, which has approximately 100 employees across the nation. I'm co-author of Question 4 from the 2016 ballot initiative. I negotiated the very first HCAs in the Commonwealth and many, many since 2013. I obtained the very first special permit for cannabis use in Massachusetts in November of 2013. We represent a significant portion of the applicants and operators throughout Mass. We were asked by 253 to help them through the host community agreement process in Sturbridge. I've worked with KP many times over the years. And so the reason I give you my background is because I want to make sure that my credentials are such that what I'm saying carries some weight, and so that I want to be a resource for the board in making this decision. So I reviewed the February 3rd video, and I was really sympathetic because there was clearly a lot of confusion as to what the board could and couldn't do. Can we enter into 2 HCAs? Should we enter into 3? I'm here hopefully to help resolve that. I've been a resource for many towns as sort of an informal town council. Unfortunately, we're here with your town council as well. Frankly, Mr. Superintendent, you were right. You can enter into 3 host community agreements. It's simple, it's direct. And that's what we're here to put forth. I think the board should enter into all 3 host community agreements. We're not here to knock any of the other applicants, and let the planning board with special permit, that's the process set forth in your bylaw. Let them sort out parking, traffic, location, safety. Those are the criteria for special permit laid out in your bylaw, and that's the role of the planning board. On February 3rd, or the last meeting last week, I heard that the majority of Sturbridge voters are against this use. That's not correct. In November of 2016, 5,522 Sturbridge voters turned out to vote, and they voted for Question 4, and it was yes. More than half of Sturbridge voters, and over 5,500 turning out, voted yes. Sturbridge is a yes town. Sturbridge is not a no town. They voted in favor of Question 4 and adult use cannabis. There was sort of a mistaken idea that HCA is a license. An HCA is not by any means a license. An HCA is basically saying, hey, go ahead and continue applying. Right, so for 253's case, and basically all of their cases, except for Heal, and we can talk about that. I don't think Heal ever even needs to get a special permit based on your zoning bylaw. But in 253's case, we'll still need a special permit from the planning board. We'll need from the Cannabis Control Commission a provisional license, a final license, a commence operations. All the host community agreement says, we vetted this applicant. We think they have the financial wherewithal. We think there's somebody we can work with in this town. 253 is in Montague. They've already shown that they're a responsible citizen. They're donating to the town. So that's all the HCA is. It's not a license. They're not getting open. They have a long way to go before they get open. They got to satisfy the planning board. And in fact, beyond the vote in 2016, in 2018, in October at your special town meeting that approved adult use cannabis zoning, 2/3 of your voters essentially approved of the 253 location. It was a contemplated location in either IP, GI, or MMOD. So 2/3 of the voters knew that this could potentially be one, and they approved that bylaw. So, Mr. Superintendent, your desire to approve all three, you are actually absolutely right. You can, and I think should do that. And I don't know, sort of the mic was off and the meeting had stopped and there was some discussion that at some point you believed that you have the ability to approve all three host community agreements, and that's simply not the case. And we can go into the details as to why in your zoning bylaw, but I don't even think Heel needs a special permit. And it's pretty clear in your zoning bylaw if you read it. So that leaves 2 special permits at your 20%, right? 2 left. So in fact, all 3 of these businesses can get open. You can give them all host community agreements, and they could actually all get open also. 253 and CPC can get special permits, and Heel can proceed with site plan approval only, according to your bylaw. So by issuing 3, they don't have to. Taunton is an example of a municipality that issued more host community agreements than special permits. So they denied denied special permits that they had originally issued host community agreements for. So it can go both ways. If we can't satisfy parking, traffic, all the location-specific criteria at the planning board, then we have to deal with it then. But you can say, okay, this is a qualified group, that's a qualified group, and that's a qualified group, and issue host community agreements. Now, Sturbridge is not absolutely required to issue a host community agreement from Heel, and I don't think, you don't take it from the applicants, take it from town council who's here. They're not absolutely required. And we can go into, under Chapter 94G, Section 3, why that is if you'd like. I know that my time is short, so I'm not going to belabor the specifics of the statute unless you'd like me to. But you're not actually required to enter in a host community agreement with them. The provision is that you can't zone them out, essentially, is what it says. So you can't change your zoning where they have a medical dispensary and say, okay, you can't do retail dispensary there. That's what that provision said. That's what it was meant to say. And so the Board of Selectmen should not, frankly, supplant the authority of the Planning Board. In addition to the 5,500 voters, 2/3 of the voters approved the bylaw under which we're proceeding. And under Sturbridge zoning bylaw 3104, the special permit granting authority is the planning board, and they should be the ones who deal with this issue at the local level. So that's impact on abutting properties, public health, safety, traffic, parking, the essential aspects of an analysis. In my opinion, none of these businesses really present a real traffic problem, but I know, Mr. Superintendent, when you were running for selectman, one of the things that you thought was really important was to deal with traffic issues on Route 20. I know at least one of the applicants before you, not us, their location is actually on Route 20. And so if one believes that these are going to create a major traffic issue, then that potentially would be the one that would not get a host community agreement. 253's proposed location is on the artery from Connecticut. If people are coming from Connecticut to get adult use cannabis in Massachusetts, they'll stop there and they won't have to drive all the way through the town. CPC's location will probably have less parking than ours. We're further from a school. We're further from Sturbridge Village. The old mobile station is well known as a traffic nightmare, particularly during rush hour. You can't make a left into that location. I mean, for a lot of reasons, if the board were to still believe that they can only issue 2 host community agreements, which I strenuously urge you to reconsider because it's just not the case, and town council's here as well, we should still be one of those 2 because our location, frankly, is better. Our location is in a cannabis dispensary with the Welcome to Sturbridge sign right on it, which I thought was kind of fun and interesting. I'm a big proponent of ending prohibition, so I thought seeing that was interesting. So the Board of Selectmen, you guys said that you had not reviewed a traffic analysis. So you weren't provided the information that the planning board will be provided when it makes this determination. And finally, you're safe giving a host community agreement to 253. They're already open in Montague. We got a letter from the town administrator in Montague saying that they're a great corporate citizen. They're a value add to the community. They've been paying host community fees. They know how to do this safely. They haven't had their license suspended. So by issuing a host community agreement to 253, you're safe. So in summary, you can absolutely issue 3 host community agreements. From watching the video of last week, it seemed really clear that the board felt like all 3 of these groups were good applicants. And so issue all 3 of them and let the planning board make the decision about the site-specific analysis. So that's my presentation, and I'm happy to answer any questions. Between Adam and I, and then your town council, and Catherine, I think you have the brain trust of cannabis for Massachusetts in this room right now. So if we want to get through these issues, we'd love to work with you on figuring out what they are. So thank you.
Okay, thank you. Hold on one second, Mary. Jonathan, do you want to come down in case there's questions? Okay, for the audience at home and here, this is Jonathan Eichman, our town council. Jonathan, I just have that first question on this idea of granting 3 as opposed to 2. What's the validity in that statement?
If I understand the question right, Madam Chairman, the question is whether the board has authority to grant 3 agreements, and that would be the 3 presented to it at this time. Is that correct?
Yes.
In my opinion, the board does have that authority.
Okay, thank you. Board, Mary?
I want to address
Yeah.
some of the concerns in the last statement, because there were some inaccuracies, and I know a lot of residents are watching as well. I think one of the things stated was, and I believe it was me, that a select person asserted that the majority of people in Sturbridge did not want cannabis. And that's not what I said. I know we were a yes community. That's why we needed to go to the local election and vote out retail and cultivation, and needed to jump the additional hoop of going to town meeting and changing our zoning bylaws. I believe council indicated to us that if we were a no community, we would not have needed the townwide vote, and we would only have needed to go to town meeting. So I also reviewed the law quite carefully. My statement was such that at our local election in 2017, the majority of Sturbridge residents, and those are the ones who voted. Of course, I can't comment on the ones who did not. But at that town-wide vote, and I will use the term overwhelmingly, but we can certainly debate that, but the majority wanted no retail cannabis stores, no manufacturing, and no cultivation. And I did go to the town clerk as well. I don't have the document directly in front of me, so I might be off by a couple of votes. So I'll state that right now. But I believe to ban them entirely was approximately 607 votes, and those that wanted them in were 425 votes. So nowhere did I state that the town of Sturbridge didn't vote to legalize cannabis. So I wanted to clarify that for the record. That's number one. Number two, I am not comfortable. I appreciate that our chair has given all 3 applicants an additional opportunity to assert their case as to why they are a desirable applicant to get a host agreement. But I am not comfortable when counsel for an applicant proceeds to tell us what the law is or to give legal advice. And it happened at the conclusion of our last meeting by one of the owners of an applicant that was extremely dissatisfied and threatening a lawsuit. And we were given legal advice from, I believe it was Wagner, as to why our interpretation of statute or our bylaws or whatever was incorrect. And we have town council, and when you're represented by council, I think we should get our direction from our own attorney as to what is permitted and what is not permitted. And I was quite aware that we are able to grant 3 host agreements, and it is also within our discretion as elected officials to grant 2 host agreements and not to give the level of authority to the planning board to determine which 2 applicants from the 3 host agreements are preferable, because our name is on the host agreement. And am I correct that we also have discretion to grant 2?
You are correct, madam.
Okay, thank you. And I also want to state that the last applicant indicated that one of the things in a host agreement is it somebody we can work with in this town? And to leave the traffic analysis and site plan approval and all that to zoning. I totally agree. I understand that site plan, the ultimate permit is not granted by us. We sign the host agreement, but we have discretion. And I took a note of that, somebody we can work with in this town. And that means that's a much less tangible, but certainly relevant, because they're going to be the other party with the town of Sturbridge. And I'm an attorney myself, I no longer practice, but I can promise you that there's no attorney that drafts language so crystal clear in any contract, whether it's a host agreement or otherwise. There's going to be disagreements on how language is interpreted. And for me, I want to enter into a contract with an applicant who is not going to challenge us to the point where a lawsuit is threatened. And that's where I'm coming from, I'll be very honest. So is it somebody we can work with? That's what's important to me. And I'm just going to say for the record, because there are people watching and they're not privy to the entire record that we were given, and I don't want to be inaccurate because I know this is going to be looked at under a microscope because we live in a litigious world.
That's
But-
not a public record, Mary.
This is not?
No.
Well, it was, okay. Nothing's public that we were given in our mailbox?
It depends on the document. Some of it is
Well,
like.
nothing is written confidential
That's
across
right.
the top.
That's right.
You know, and so if something
Right.
is confidential, it should have been written confidential across the top. So I'll just leave it at that, but for me, that's going to weigh very heavily. And I did make a comment about professionalism, and that I think all three applicants say you're all qualified, you're all suitable. Well, suitable is also, can we get along with you as a town? Can we get along with this business and be amicable? And that is my concern, because the last meeting, at the end, I would not describe it as being as amicable as it could be. And I think that's a shame, and I wanted to state it for the record.
Priscilla, first of all, does anyone have any questions of the
I have a question of the
proponents?
attorney.
Okay.
Okay. I need some guidance, because I'm looking at the zoning bylaws, which the other attorney stated that all this went to the town meeting. And at the town meeting, this is what was approved. And it says in 31.03, the number of marijuana retailers that shall be permitted in town shall be limited to 20% of the number of licenses issued within the town of Sturbridge for the retail sale of alcoholic beverages, not to be drunk on the premises. I asked the town planner recently, I asked so I would know exactly how many of these establishments there were, and she's right here, you can verify it. She replied in an email that there were currently 8. If you take 20% of 8, you get 1.6, and this goes on to say, in the event that 20% of said licenses is not a whole number, the limit shall be rounded up to the nearest whole number. Last night, I attended a planning board meeting, and the question came up about having 3 retail licenses, and the town administrator was there, and he said, no, it's 2 because of the 20%. You would need about 13 or 14 of those licenses in order to get to 3. And so I guess I'm confused as I'm hearing, yes, you can have 3. What do we bother to do bylaws and amendments for and bring them to the town meeting and then say, okay, town, you voted this in, you accepted this, now we as a Board of Selectmen are saying, sorry, we decide to read it different. That's where I have a big problem.
Through you, Madam Chair, I didn't hear a question there, but I think...
How are you justifying it?
How am I justifying?
How are you justifying 3?
I'm not justifying 3. It's the discretion of the board if they want to allow
How do
3.
you, okay, then help me. Where are you seeing that? Because as I read this, it's pretty black and white to me.
Correct. This is a zoning bylaw, however. This is places authority for the planning board to issue special permits. This is a limitation on that authority. As council has pointed out correctly, this board is essentially a gatekeeper for adult use establishments in the town. Before you can apply for a license with the Cannabis Control Commission, you have to have a host community agreement with the town. Therefore, they're in front of you looking for that agreement. If you give them an agreement, that does not mean that they get a license. That's the first step. They have to go through the process with the state. They also have to obtain their local permits. The bylaw says that they need a special permit. That limitation is 2, so when it gets to that point, the planning board will be bound by that limitation. They can only grant 2. But you,
That's not
the
what we
board,
were told.
may,
That's
Excuse me.
not, I beg.
Wait a
I'm
minute,
sorry.
Mary.
That's not what we were told. That's not my understanding at all.
Wait a minute,
wait,
Please, settle down.
yeah. Wait a minute.
We have an attorney.
We have a person asking. No, Jonathan, that's always been the confusion. I mean, you know, we do understand that the CCC is the only one that gives a license, that the host community agreement is the first step here. And we've always been under the understanding we need to follow what will be presented to the planning board, you know, according to the bylaw that, you know, that 2, only 2. So, you know, we could maybe take in 8 host community agreements, and then they could go to the planning board. But I don't see where it's the planning board's job to make a decision at that point. They would make a decision on, you know, site plan and all that. So I don't think it's their job to take, say, 8, you know, and whittle it down. Well, this one's this. I think it's our job to work so that we're working along with the bylaw, and that's what, you know, we move forward with. That's just my interpretation.
I agree with that.
Yeah. Mary?
May I?
Yes,
And I have a
please.
couple of questions, but I wanted to relate it to Priscilla now, as well as our chair. I think, and I want to put words in your mouth, but my understanding is we can sign more host agreements, but what it ultimately does is put the decision as who the 2 applicants who are successful in the hands of the planning board rather than in our hands, because we signed several host agreements.
I hear that, but what, I
Okay.
was under the understanding that we
I-
were going to pick
Well,
the
we
2.
have discretion, we have, right, and that was our, as a policy board, that was what
Right.
we wanted to do, is have our discretion and put forward 2 host agreements, so that ultimately it wasn't the planning board deciding. And we do have discretion to enter 2, 3, 4, correct?
Correct.
Okay, and then I have a couple of questions, because on more than one occasion now, applicants have been talking about Connecticut. Now, is it legal to carry cannabis across interstate lines at this point? It's not funny, it's
Chuckle.
my, I don't want to.
I don't know Connecticut law. I think it could be illegal, not because you're, I mean, I think there's a federal problem with that.
Correct.
Because it would be interstate commerce. That's number
Correct.
1. Number 2, taking into Connecticut might be a problem as well. I don't know Connecticut law.
Right, but in terms of federal law,
Correct.
because federal law governs interstate commerce,
Yes.
then it would be a federal crime, correct, under the current so those hoping to like benefit from Connecticut's market may face a federal challenge if it's carried across state lines.
Correct. Technically, the buyers are not engaged in commerce, but the federal rules would apply to people coming across state
Okay,
lines.
I just wanted.
Chase?
I just want to clarify one thing. So if we send 3 licenses to our planning board, at the end, there will only be 2. After planning, after zoning,
So the planning board's going to have to look at those 3 on their individual merit and decide whether the 3 are entitled to, each of the 3 is entitled to a special permit. They may be 1, there may be 2, there can't be 3 because they're controlled by the bylaw, but there could be none. They could decide that none of them are entitled to a special permit. It depends on whether they meet the criteria.
thank you.
Mike?
I have a question. Do breweries that sell alcohol for consumption off premises, are they counted in the number of licensed establishments under our bylaw?
This is to be drunk on the premises, so I would say if the license is to drunk off the premises, they won't be counted.
Now, these licenses are to be,
Yeah,
says to be
off-premise
trend-
consumption.
Not to be drunk, excuse me, package stores.
Not to be drunk.
I flipped it, you're correct, yes.
Okay. So are they included?
But don't most breweries have both? I can't think of one that we have that just brews.
But all of them sell alcohol to be drunk off premises.
Yeah, but in the bylaw, it's
And
strictly,
growlers or...
it's, the
I'm
bylaw
wondering
though is
if-
strictly all
My
off.
question is that, are those establishments to be counted?
If they have that kind of license, yes, you count them. I don't think it matters that they have another kind of license as well.
Okay. In addition to the 8 that are counted, there are 3 breweries in town that do such. So that would bring us up to 11 establishments. And they'll take 20% of that, that's 2.2, you round up to 3. If we had 11 establishments within town
That would be
that
correct.
sold alcohol off premises.
If that, yes, if that number is correct, then 2.2 would be rounded to 3.
Just a question.
Well, just on that, 1 second, just on that stream though, I thought the 20%, and perhaps, Jean, you know, could you come down, please? I thought the not to be drunk on premise, the off-premise, didn't entail a brewery because...
No, they're
it's
issued under a different
different.
chapter, I believe. And I don't have my bylaw in front of me, but the licenses are Mass General Laws, Chapter 138, Section 15. And I believe that the brewery licenses are a different section. And so when I got the tally directly from our list of licenses, I picked only those that are issued under Mass General Laws, Chapter 138, Section 15, and we have 8 of those.
I agree, yeah, that's why I had the question. is,
Okay.
Because of the off-premises, the wording in the wording in our bylaw versus the general laws for how you determine the 20% might be, I don't know.
I believe that wording is taken from the statute.
Okay. So the answer to my question would be, no, you don't count the breweries.
Correct.
Correct, and my answer was that if they had that license, you count them. They don't, so you
Okay.
don't.
Mary?
I just want to go back to something I said. So we were given documents in our mailbox, and I was just told by our town administrator that it's not a public record. And I guess as my attorney, were we given privileged documents that weren't marked privileged or confidential?
I haven't been asked that question yet, but in my opinion, those documents were provided to me as the town council. I conveyed them to the town. That's my job as town council. Those documents were provided by a public person. They are now in the town possession. They would be public documents.
Thank you. So I'd like to refer to it.
That's fine.
For those viewing, we were given in our packets a order, plaintiff's ex parte motion for temporary restraining order, 253 organic plaintiff versus the town of Sturbridge defendant, dated. Obviously, I guess I don't want to speak for them, but I'm assuming these have not been filed yet. But have they been filed?
Not that I've been aware. If
Okay.
they've been filed, they should be served upon the town. I'm not aware they have been.
Okay, but we were given this document. It goes on, and basically, there's the motion for a temporary restraining order prohibiting us from entering into any host agreements with anybody else. It goes on, affidavits. I see one factually incorrect statement, but. And this is from one of the applicants here tonight. So I'm not sure why it's being shared with us. And I don't want to speak for anybody, but to me, this is something that is, I don't know, Am I incorrect to say, why were we given this?
I don't know.
In anticipation of a certain action? And I guess I'd like to ask the applicant, point blank. I certainly didn't have time to read all of it because it was given to us, I don't know, maybe an hour before the meeting, or I don't know, somebody else would know best.
Yes.
But why was this shared with us?
Through the chair.
Chair.
before I say Yeah, Madam Chair, Adam Fine. The question was about the documents. So the documents, our client asked to send the documents. They were not prepared by our firm, but the documents were, I mean, simply what they are, which is legal. They were not filed. They're in draft format. And I think to the credit of this board, the taint or the lack of what occurred at the last meeting, I think the board kind of recognized that it was worthy to have this public hearing. And those documents were provided simply to let the town know that that the applicant, should be able to enforce its legal rights. And there is irreparable harm if there's a problem in the process, or there's a problem in procedure, or there's a problem, frankly, with the host agreements themselves. And the applicant should, I think, be afforded the right to have, its legal rights, have process in its legal rights. But these were draft documents. They were not filed. And to the credit of this board for having this hearing, there was no necessity to file them.
But they were shared with us in anticipation of this
Well,
meeting.
respectfully, they were shared with council. I was not aware that the council was going to be sharing it, and I did make a couple phone calls to council to chat with them and provide more context. But
Is he under a duty to share documents with us because we're his client? Did you think it was going to stop with council and not share?
Council did share them.
I think that the applicant should be able to have interactions with your town council. And if you'll see, I actually sent the email, so and I think the thought is, and the hope is that the town of Sturbridge, through the chair and the board, would follow the law and act in a fair manner to the applicants. I think that's not too much to ask. They've invested a lot. They negotiated in good faith with the town for the host agreements. I think that point really should be emphasized. There was a process to do this. And many cities and towns followed that process. And this applicant, and I appreciate what you said, Ms. Dowling, about the comments that were said at the end of the last meeting. I wasn't here. I certainly watched the video, and I appreciate your reaction to that. And I hope that you can kind of push, not have that be prejudicial to your determination, and put yourself in the applicant's shoes as to all they've invested in the city or town, and they're asking for a fair shake. And I think when we sit here today, and I think the fair shake is allow them to go to planning board and make their case on the merits. And I think that's particularly important in this matter because they went through a deliberative negotiating process with the town in good faith that they would be able to enter into these agreements and move forward to planning, as I think the process should go out. And so I'm sorry, respectfully to the whole board, sorry, it was not meant as a point of agitation. It was meant as a point that I certainly think my client should expect that the process plays out in a fair manner. And that's all it is. And again, to the credit of this board for having this hearing, I think that goes a long way. Well, and I think that the issue that was brought up was following the law and what the law says and how many local licenses we can have. And I think we continue to have confusion on that. And I think the portion of the bylaw that was cited was B. You have to combine that with A in the bylaw. And so, Seth, do you think you grab that poster? Is that okay? Because I think this is important because how many marijuana retailers are you going to can you wind up with at the end of the day, right? That's something of a question that the board has. How many can we wind up with? And my answer is you can wind up with 3, and I'll show you why. Okay, thank you. And so the language from the bylaw says, with the exception of the conversion of a licensed registered marijuana dispensary to an adult use marijuana establishment, an adult use marijuana establishment shall be permitted by special permit. With the exception of Heal, an adult use marijuana establishment is special permit. Then you go on to B, the number of retailers that shall be permitted is 20%. So Heal gets 1, and then you have the 20% on the 8 licenses. And that's what your bylaw says. And so I don't know how else to interpret that. It's pretty darn clear. And so if the question is that how many can we wind up with, you can wind up with 3. And I mean, that's what the bylaw says. Look, it's just me reading the bylaw. I have it printed. I didn't redact any of it. I left this, so.
Okay, Mr.
I want to clarify something. We don't have an application for conversion. We have a separate and distinct entity owned by Heal who's seeking an HCA separate and distinct from the medical marijuana operation. So it's not a conversion. So that section doesn't apply in this instance.
So that's actually great. So that sort of adds to the ambiguity. Mr. Superintendent at the hearing last week, there should never have been an off-the-mic conversation about only being able to do 2, right? Because, I mean,
First of all, I want to interrupt. There was no off-the-mic conversation when the parties left. As a matter of fact, when Mr. Supranat first brought up, he wanted to, I said, you have to wait. He hadn't made a motion yet. And my point of view all along with the conversion has been, we can give 2, and going back to Heal Inc., not Heal Sturbridge Inc., who's looking for a agreement. Heal Inc. can apply for a conversion next week down the road, and then they'd have to come back and get a host agreement. And that way, we would have 3.
Through the chair, so when I heard Ms. Adams speak, that there was a reference to 94G, and I'm sorry if I was under the impression from watching the last hearing and from watching the beginning of this one also, that Heal was proceeding under the theory that they were already a provisionally licensed medical marijuana establishment before July of 2017. If that's not the theory that they're proceeding under in the town, then certainly this argument, this interpretation of your bylaw isn't accurate. But from watching the last meeting and also from listening to Ms. Adams at the beginning of this one, my understanding was that was the theory that they were proceeding in the town.
No, it's 2 entities. Okay, Mary?
I'm still on this document, okay? I just have a question. Can you answer it, or you cannot answer it? If we don't sign a host agreement with 253 Organic, is this going to be filed in court against the town of Sturbridge if we don't enter into a host agreement with you?
I am not litigation counsel for the applicant, so I'm not.
You're not going to answer that
We are not,
question.
so I'm not prepared.
Do you know why it was shared with our council?
I believe it was shared I think it was shared because it was very clear. Unfortunately, there was at the end of the last meeting, there was obviously some emotions. Okay, I wasn't here. I don't want to speak, but it was clear. So I really would ask that you take that out of the purview and just understand where the applicant was coming from. They got awarded a Hody use agreement. They went down the aisle. They thanked everybody. They left the building. And then they came to find out that they didn't have it. And that, you got sitting in their shoes. I would just ask yourself to put themselves in their shoes. I hope you could understand why they reacted the way they did. The reality is, as lawyers, and I'm speaking generally, we advise our clients on what their rights are. And in that instance, when host agreements issue, as your town council has pointed out, that allows an applicant to apply to the state. And that in and of itself, and we saw this in Cambridge, for example, Cambridge versus the Rev Clinics, that does cause irreparable harm, or could cause irreparable harm to an applicant. And the remedy for that under the law is a temporary restraining order if the town is taking a position that's contrary to, if we think that there's legal rights and claims that exist. If the town is not willing to enter into negotiation or anyone to have a discussion about why we think legal rights were violated. And so I respectfully, I hope that you don't hold an applicant in disregard or not issue a host agreement simply because they're asserting the rights that they're allowed to, or letting town council know that they're serious and prepared to assert the rights should they need to, if they feel that they've been aggrieved by a town. And I think that would be, I think that something a town should consider because no one wants to enter into litigation, I believe. I don't believe the applicant does. and I think it's a unnecessary cost to the town and to the applicants involved.
So let me just see if I understand you correctly. You're not litigation counsel, so my very simple question of if we don't enter into a hoster agreement, is this going to be filed? I'm reading you
I don't
as
have
saying
it.
you don't have any answer to
I
that.
would
because you're
suggest,
not
I would
litigation
suggest to
counsel.
this board, based on what I know, not as being litigation counsel, that my client would be prepared to fully research, understand what their rights are, and I believe that, that legal rights have accrued, and they would make a determination. But I certainly think that,
May I ask where litigation counsel is this evening? Is litigation counsel here this evening?
Unfortunately not, but as far as the rights that the applicant would be prepared to assert, as a co-author of Question 4, work closely with the legislature that did this host community agreement provision in the law when the legislature rewrote the ballot initiative that we wrote. Host community agreements were never meant for the Board of Selectmen to be a gatekeeper to prohibit a legal business in Massachusetts. This is a legal business in Massachusetts in a properly zoned area. That's not what they're for. They're to set up the terms between the Board of Selectmen and the parties. Full transparency with local law enforcement, preferential local hiring, 3% of revenue, all the bells and whistles that go along with, but they're not supposed to be a method of prohibiting a state legal business because the board doesn't like the cut of their jib, or they wanted to exercise their rights, or the board is doing a traffic analysis without ever having done a traffic analysis. That's not what they're for. They're to make sure that all the concerns of the community in this operation of the business are laid out, but they are absolutely not a method of prohibiting a state legal business. That's just not the purpose of a host community agreement.
and if I could just
It
add,
is the purpose to see if it's somebody we can work with in this town.
The purpose is to lay out the terms between you and the applicant, is to see whether, this
And
is,
if we can work with
it's a
them.
gatekeeping function. I'm speaking loosely.
Ms. Sullivan, I could just add, one of the other things, and I mentioned this to town council, I was very forceful about this. I did not, when we looked at this from a completely, when we came into it, one of the things that stood out to me was that it seemed to me that the process in the town had already taken its course. The bell had been rung. The idea was we're going to enter into these host agreements, we're going to negotiate in good faith, and we're going to issue the host agreements and go to plan. That's what it looked like. When the town came back and asked the town did come back, and I think that was in consultation with council, and asked for stuff which we believe in this firms, and we disagree with KP Law on this, but this issue has come to a fore. One of the concerns we had, in addition to the other concerns, was we feel that the host agreements, I just want to be clear, the host agreement should issue to all three groups. I think that's a fair and equitable result here. That it should be in the purview of the planning board, and that the host agreements themselves should not exceed 3% under the law, and that's a really hot issue right now. And that was one of the issues that we also did. So to the extent that that in my opinion, and I sit here as on the other side, so I'm not here your town council. This applicant, I would say you issue them a host agreement. They will provide you, and we will provide you, and work as hard as we can to make it clear that they can work with this town, because I am confident that they can. I think you saw a visceral. I don't think that is representative of this group, and we do have a representative of the group here today. They are committed to giving back to the town in every manner that they have. It's why they committed to the host agreement and the funds in there. So I would ask that you give the applicant a chance, allow them to go to the planning board, make their case, and they will work as hard as they can to ensure that this board and boards in the future are comfortable and happy working with this particular group. And I do think they will work well with the town.
Just as they have with the town of Montague, and they're open, paying host community agreement fees with a letter of recommendation from the town administrator in Montague. It's a good group. I think the way Adam said it is right. There was a visceral reaction at the end. You were given something, and then immediately it was taken away. And I think Ms. Wagner, erupted and felt viscerally upset about that. But this is a good group. You've all worked with Seth for a while now, as he's been coming back and forth in the town. And to deny a host community agreement because they're exploring what their rights were, because they felt like the process, was difficult for them. Certainly, it's another reason not to deny a host community agreement.
Madam Chair, may I make a quick comment here? I heard one comment I think the board needs to hear, town council's opinion on, that's that the Board of Selectmen cannot act as a gatekeeper. I think Board of Selectmen absolutely can act as a gatekeeper. And in fact, the one case that we have from the courts of Massachusetts indicate that very fact. So I think that's incorrect to say.
Yeah.
Can you give me the site of that case? Do you have it? Whenever you have it.
Yes, I can give it to you
Okay,
afterwards.
thank
It's a Superior Court case involving the city of Salem.
And what are the, do you remember the facts or?
They had multiple host community agreements, and they granted us 2 or 3, I think it was 3, maybe 4, I think it was 3, and they denied 2. And
They didn't
were-
negotiate with them, though, before they denied it. I think that's a factual difference. that's
Anyway,
important.
there may be factual differences, but what the court did was affirm the board's ability to deny a host community agreement based on reasonable grounds.
So do you feel we're legally entitled to grant 2 host agreements and not 3 this evening?
Yes, you have the authority to do that.
Legally?
Yes.
Okay,
If you have a
thank you.
reasonable basis for your decision, you may do that.
Chase?
Okay, you want me to start off?
Oh, well, I was wondering, any more questions?
No,
or-
I have no further questions.
Mike, any more questions?
No,
Positive?
I've heard enough.
No, and counsel, I will have to agree with you on the point that 253 has been very cooperative all along. And I firmly believe it was understandable, because I myself was upset that the rug had been pulled out, so.
They're good, they're good people. And, I've gotten
I
to know them, and
I don't doubt it. We all
yeah,
have
it's-
outbursts. Okay, so, thank you.
Thank you, Madam Chair.
Thank you, Madam Chair.
Okay, now, let's look at the motions here for reconsideration. The first one, please.
Yeah, can I start off with my statement?
Oh, sure.
All right. I asked for this meeting after the events that took place at our last. I feel we are at legal risk, financial risk, and reputational risk. I take issue with the fact that we have told all 3 of these applicants at some point in time that they would be receiving an HCA. At our last board meeting, we voted to grant 253 a host community agreement. All 5 of us shook their hands, congratulated them, and then it was reversed. Throughout this process, I have been very transparent about only wanting 2 establishments. After what transpired, I feel it would be best for the town to enter into 3 host community agreements with the 3 applicants. And after talking with town council tonight, I'm very happy that we did have this meeting, because I certainly learned a lot. And I think it's important for us to send 3 applicants to planning board. I agree, 4 or 5 applicants going to planning board to pick 2, that, I don't agree with that. But 3, if I were sitting on planning board, I would want to be privy to the information of traffic studies, of site plan reviews. They're going to have all that, and they're going to pick the 2 best applicants for this town. If we only send them 2 for 2, I don't see how that's beneficial. I think we send 3 applicants to planning, and they will pick the best 2 of their site.
Mike?
Based on my research and also the, conversations that I've had with people in the various towns that all 3 of the applicants have, been involved with, I found that all 3 applicants were qualified to enter into a host community agreement with the town, and I've stated it before, but I think that we should issue 3 HCA's, and then the ultimate decision of the planning board would be based on our bylaw. At this point, I think that, and it's not that I don't think that the Board of Selectmen couldn't be the gatekeeper. I think we very well could. If we had an applicant here that was totally not or even substantially not qualified, I would vote no. But I think all 3 of the applicants are qualified to have an establishment for retail adult use marijuana. We've been looking into this for months, and based on my research, I really can't rule out any one of them.
Only months?
Well,
It's been.
yeah, it's been a long time.
Okay, so then let's look at the, Priscilla?
The water was muddy when I walked in, and it got a little bit muddier in the sense that I truly always understood and believed that it was our purview to pick 2 of 3, or to pick out of these 3. It was my understanding that we would then send them to planning, and planning would then site plan review and everything. That was their job. I didn't understand at any point in time that we were just going to banter this for hours and hours and weeks, and then turn around and say, okay, here you go, planning, there's 3. They could have done that to begin with. And they could have come to us and said, these are the 2 that we picked. I think that, I'm not sure I understand this process at all, and that's why I'm saying, it walked in, it was muddy. I think it's muddier now, because I truly believe that was what was supposed to happen. We bring them to planning and say, this is what we picked, now you do what you need to do with them. And that's how I understood our position to be. But obviously, somewhere along the way, I'm not sure I missed something, but this is what I truly believe.
Mary?
It's very clear how the vote's going to go tonight, so I will say for the record that I'm extremely disappointed. I think it's the discretion of the board to have entered into the amount of host agreements, and the understanding of this board for many months was that we were going to enter into 2 host agreements. We directed our town administrator to negotiate with all 3 so we could pick the 2 host agreements that we thought were the most beneficial to the town. And it was raised, do you want me to negotiate 2 only and bring you those 2? And we said, no, we would like to select from the 2. Now, it's very clear that I think the majority of the board is going to vote for 3, but I'm going to say for the record, I think this board shirked its responsibility. I think we've now put it in planning board's hands as to which 2 they wanted, and I think we are the representatives of the people. And again, the majority didn't want any. And now it very well could be 3, because the 2 that could be granted the licenses could be or 253 Organic, the ones who gave us these court documents that haven't been filed, and caregivers. And then when the agreement is lifted, HEAL will move forward under the statute and convert from medical to recreational, and the zoning bylaw is not going to be able to change that. And then lo and behold, when residents thought we were getting 2, we're going to have 3, or we will have 2 plus a medical. And I thought it was up to us to come up with 2 host agreements, and I am extremely disappointed in the process. And I will also say, for the record, that somebody we can work with in the town, and this board is going to sign a host agreement with an applicant who had a, to use their term, visceral approach, because it didn't go their way. Well, I watched an applicant who was qualified look disappointed, and exit the building in a professional manner when they were not the chosen ones. And that's how I would have expected other applicants to be. And they were disappointed initially because they were qualified, but I didn't see that applicant come up to the board and say, you are under an obligation to enter into a host agreement with us. They left, they were disappointed. And I, for one, would never sign a host agreement. I hope that with a majority vote, town council, are we all required to have a signature on a host agreement? Is that a requirement?
No.
Only the majority of the board?
Yes.
Yeah, I would not be strong-armed into a host agreement. And with all due respect, one of the owners, one of the applicants, is not even here tonight to express whatever to the board. Not even here tonight. And I'm very disappointed with the board passing it on to the planning board.
Okay,
Mr. Bridges? Thank you. I just want clarification from the town council. The motion with HEAL had 2 pieces to it.
Correct.
to approve and enter a proposed host community agreement with Heel Sturbridge, Inc. for retail adult use marijuana, and in conjunction therewith, to approve and enter a proposed amendment to the existing host community agreement with Heel, Inc. for a medical marijuana treatment center at the same location. That amendment memorializes its inability to convert, as long as it has a retail HCA with Heel Sturbridge.
That is correct.
Okay.
Okay, let's.
Madam
get-
Chair?
Oh.
One point on that, it's a good point, I was looking at that, when the town administrator was speaking. If there's a motion that passes to reconsider Heel, the motion to approve should include the language to also include the amendment. That was omitted from the original motion. However, there may be no need to reconsider, in which case that original vote would stand.
Well, right now, we have a motion, this is a motion to reconsider our decision to enter into a host agreement.
Right. The floor would be open right now for motions to reconsider.
Consider.
Okay.
And then the second part. Okay, you all have the motions? Okay, first one, does anybody want to make that motion for reconsideration?
Madam Chair, can I ask a question?
Oh, yes.
So my question is, if the board does vote to reconsider issue 3 HDAs tonight, is the planning board going to view all 3 applicants at the same time? Or is it a race to see who gets there first? Because we're at an inherent disadvantage because we have to do some more site plan and survey work versus an existing building. And so if the planning board is going to view on a first come, first served basis, you basically have eliminated us tonight. So again, in the interest of fairness, we're just trying to figure out how it's going to work going forward.
Jean, how would it go?
It would be first come, first served, because we are obligated to hold the public hearing within 65 days of the date of submittal. So, you know, if there's a big gap, then obviously first one in is going to be first one out. So unless they don't meet some of the criteria, then they would be awarded the special permit.
Madam Chair,
So-
just to point out, once they get into the process, the first come, first served may apply to how they take up the applications, but with a special permit, that process is dependent on the information they submit to the board, and if more information is required, one permit applicant may run longer than the other. There's no guarantee that if you get in first, you're going to get out first.
Okay, did you hear that?
I did. Again, we're at a very significant disadvantage because of what's required of our site.
Okay. So, the first motion says, I move to reconsider the board's vote taken at its February 3rd, 2020 meeting not to enter into a host community agreement with 253 Organic LLC. Someone want to make that motion, even though I read it?
Do you mind if we just revisit that point real quick?
No?
So I just want to make this clear, because I do not feel it's fair to caregiver, and I don't want to put them in that situation that they're out of this race because of the timing. If they file a special permit, it will get them time to get their application right in the board.
No, they need to have a complete submittal before they can file. So that means they need complete site plans, architectural plans, traffic study, any environmental issues. I think there's potentially some wetlands in the back. So all of that needs to be, I'm sorry, Madam
No,
Chair.
no.
Sorry. All of that needs to
Nodded.
be submitted at the same time. That's their complete submittal. Without a complete submittal, we can't go forward. And I will say that they are correct. They don't have their plans ready. They're waiting for this process to unfold.
Yeah.
Very briefly, if I may.
2 sentences.
Every applicant special permit has its own issues. We have wetlands issues. We're the biggest disadvantage. Yeah, we're not anywhere further in front or behind the wetlands issues as well. I mean, that's the point of the planning. Yeah.
I'm sorry.
No, go ahead, Jean,
So
continue.
253 does have a site plan prepared where caregiver does not yet. So, and yes, every site has their own, but I think that in doing this way, I think they're absolutely right. Whoever can get all those documents finalized first is obviously going to be the first one that we schedule, and they may or may not have everything, and it may be continued for a time, but
That's the way it goes.
yeah.
Okay, Mary?
I just want to say again, all of the applicants, as well as the board, was under the impression that we were negotiating with all three, and the Board of Selectmen were going to select 2 applicants. And any resident can watch the meeting minutes, because all 3 applicants tried to convince us as to why they were the preferable applicant. So they were all on the same page. And I think caregivers is at a big disadvantage now for this Board of Selectmen to suddenly say, no, we're prepared to sign all 3 host agreements and leave it up to the planning board to decide which 2 get the special permits. Because all 3 have been negotiating with the understanding that they wanted to be the one. And it was certainly true at our last meeting, because as the motions went up, and we approved 2, 1 applicant left because they know that they weren't one of the ones chosen, because everybody was on the same page that this Board of Selectmen were going to decide the 2 applicants with the best host agreements and whether they could work with the town and all the intangibles, and we were going to send 2 applicants to the planning board. And now we put a disadvantage to all 3 of them. We were all playing by the same rules until this meeting.
No, not true.
Yes, yes, true.
We were going to send,
Yes, true.
we were gonna send 2, and we told all 3 of them at some point that they were going to.
No, we never did.
No,
They
we
were all
didn't.
competing for
No,
those
we
2
didn't.
host agreements.
Wait a minute. Let's, and please, could the audience?
Can I ask the question of the attorney?
Yes.
I totally agree. Selectman Dowling is absolutely correct, and I said that just 5 minutes ago. Where do we sit now? I mean, I believe that something went wrong here in this whole process. So the process we understood, we picked 2 of the potential 3 that come before us, whoever they may have been at the time. We did our due diligence for months, weeks, everything, from drafts to final copies and everything, with the understanding that it was our call. And here we are now, and it's not our call. So we're going to take all these 3 people, and caregiver is at a very serious disadvantage. They don't have a chance. That's not fair. It's not at all fair. And the whole process right now, as far as I'm concerned, is not fair. If it's going to change midstream, the rules have changed. I have a serious issue with this.
Priscilla, I don't think the rules have changed as far as,
Have, Mary, because
wait a minute, Priscilla. As far as all the proponents have issues, when they get their packet together, they know it has to be a complete packet for planning board. That's
not my point, though. That you missed my point.
Yes, I did then.
My point was, it was my understanding all along that the Board of Selectmen were going to choose 2 of any 3 potential candidates. I take the picture out of all of the names.
I don't disagree with you, because that's what my interpretation was.
Well, then when did this interpretation get on its head? Because it changed.
Tonight's meeting.
Tonight's meeting.
When we decided to go forward with 3.
Tonight's meeting changed.
meeting.
Yeah, but it's not only
wait a
the
minute,
3.
wait a minute, we have.
It's not only the 3.
Yeah, but-
It's now we're giving it to planning.
No, we haven't decided any of that yet. We haven't decided. 2 people expressed their opinion that they would like 3. We don't have any motions or anything. We have these motions, is what we're looking at. So, wait a minute, Mary, okay? And I firmly believe that it goes to planning, but it's up to us to pick 2 to send to planning. It's not their,
Yes.
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 It's not
Yes.
their
Yes.
job to
Yes.
pick and choose.
Yes,
you
now
know?
you're talking. We're on the same page now.
Yes.
But a few minutes ago, that's not how it was going.
No, I've said that all along, because even, you know how I feel about 2 and 1.
Oh, I told him
Yeah.
that you're exactly
And
right
I
about that.
have not changed my opinion. The planning board does their job and we do our job.
That's right, exactly.
Okay,
I
Mary?
just want clarification on one more thing from our council. Is it your opinion that when we had a motion to reconsider and we re-voted, do you feel that the process was lawful?
Yes, I do.
Okay, thank you.
Madam Chair, could I say one thing? Last thing, I promise.
Not only a promise, you're darn right.
I would suggest, and this is just hearing the debate here, and I wasn't here last time, I would suggest that to the extent there's any doubt here today, we would ask that the board continue this for a period, to the extent that there's doubt, because there's some serious issues at play, and I appreciate Ms. Dowland's considerations of what she mentioned, but I would suggest that to the extent that the board is not going to grant three, and what I believe, truly believe is fair to all applicants, and everyone has, planning boards commonly are aware of this issue, and we'll wait for the applicants to be complete, and we'll hear them all, we'll hear them all on the same time period. That can be adjusted to the planning board. But to the extent that there's that, I would ask that this be continued and reserved so we have, further discussions on it, or perhaps more process.
Yeah, we have gone through this process thoroughly, and it seems the more we go through it, the more boggled we get. So I, for one, am not taking any consideration to postpone it. So let's look at the motions we have for reconsideration. I read the first one. Is there anyone that wants to make that motion?
I'll make that motion. I move to approve and enter into a host community agreement with 253 Organic LLCs in the form of...
Excuse me, Madam Chair, the motion was to reconsider that you read.
Yeah, we're doing the reconsider.
Oh, I'm sorry.
After we go through all the reconsiders, then we'll go make a new motion, maybe.
Repeat your motion, I'm not sure what you guys are voting on.
We're not either.
Reconsiderations.
Of
Well, he's going to read it again.
I move to reconsider the board's vote taken at its February 3rd, 2020 meeting not to enter into a host community agreement with 253 Organic LLC.
Okay, I'll second that. Any discussion? All in favor of the motion? 3, all opposed? 2. Okay. Second motion is I move to reconsider the board's vote taken at its February 3rd, 2020 meeting to enter into a host community agreement with Caregiver Patient Connection LLC. Someone willing to make that motion?
I'll make that motion.
Okay, someone want to second it?
Second.
Okay, the third motion, I move to
Madam
Gonna
Chair,
vote on it.
your
Oh, I'm
vote.
sorry. See, I told you we've been at it too long. Okay, all those in favor of that motion? All those opposed? 3-2. Okay, 3. I move to reconsider the board's vote taken at its February 3rd, 2020 meeting to enter into a host agreement with Heel Sturbridge Incorporated. Someone want to make that motion?
I move to reconsider the board's vote taken at its February 3rd, 2020 meeting to enter into a host community agreement with Heel Sturbridge, Inc.
And I have a question.
Jeff?
That would include the additional language regarding the amendment to the medical.
At this point, it's just a motion to reconsider. We haven't
Yeah.
got to the
But it
point.
would reconsider the whole former
It would-
motion.
yeah, whatever that last vote was, correct?
Okay.
Okay. Who made that?
I did.
Okay, is there a second? Hearing no second, that motion fails. Okay. Now the motions.
She's got a question. I don't know if you want to acknowledge her or not.
Karen, I think we've had enough discussion
I just wanted to ask procedurally how you can present with the motions, because if you ask to approve one and it is approved, then it automatically eliminates the second one.
Well, we haven't gotten down to the motions that we're reconsidering. Those were just motions to reconsider.
But I would say she's
Got a good
correct.
point.
Yeah, how are you gonna reconcile that?
We'll see.
So then that one stands. Would that be correct, Joel? That one would stand, yes.
Excuse me? I'm sorry.
That one would stand.
That
Yeah,
Heels
I'm
vote would
prepared-
stand?
I'm
Yeah.
prepared to make a motion now that we've done all the reconsideration.
Wait a minute.
Have we already done all three?
Yes, but we have motions down here.
I know, but why do we have to, I guess that what I'm asking is why do we have to go in that order?
We haven't,
I'd
We
like-
don't.
Okay, so
Mary?
I move to approve and enter into a host agreement with Caregiver-Patient Connection in the form presented, as that form has been modified in accordance with the board's prior vote for the operation of a retail adult-use marijuana establishment at 365 Main Street.
Second.
Any discussion? Just getting this down. Okay. All those in favor? Okay. Okay, is there another motion then?
I move to approve and enter into a host community agreement with 253 Organic LLC in the form presented, as that form has been modified in accordance with the board's prior vote for the operation of a retail adult-use marijuana establishment at 138 Main Street.
Okay, I'll second that. Any discussion? All in favor? 3-2.
Oh, yeah, you didn't take the opposed? I'm sorry, I didn't put my hand up in time.
Well, no, but
Did you
I-
know? Okay.
I could read your mind.
Okay, so
Plus
we,
this one.
so we did enter into 3 host agreements.
Yes.
Yes.
So we're in a quandary.
And so we
We're
did
doing
put
the
one
same
applicant
thing.
at a distinct disadvantage.
exactly.
And everybody was on the same page that we were going to agree to 2 host agreements. I'm very disappointed in the process.
Now I question this process. And I really do, because this isn't what we're supposed to do, this isn't what we were prepared to do, and this is what we weren't charged to do. And now we're doing, all of a sudden tonight,
What
something.
we didn't want to do.
And it's very unfair to caregiver, very unfair.
Jonathan,
didn't,
Madam Chair,
I've got a question.
we voted for 3.
Okay.
That's it, unless somebody makes another motion to reconsider a motion.
you've gone through all the motions. You voted on all 3 of them.
Yes. Michael, you have a question?
Yeah, I had a question. Somebody stated tonight that it takes several months to get through the Cannabis Control Commission, the licensures. And that's one of the requirements that's one of the submission requirements for a special permit. So it's several months down the road before anybody can apply.
Not really.
Well, one of
According
the,
to what 253 said, they were ready.
well, they got to go to the Cannabis Control Commission and get registration or licensure. And I'm just asking the question. It was stated that it takes, quite a bit of time to get that. So it may not be as inequitable as we're, stating right now.
Well, this whole process, with all due respect, every applicant, the Board of Selectmen, the town administrator, everybody was on notice that we wanted our town administrator to negotiate 3 host agreements, and we were going to decide on the 2 host agreements that we found were the most advantageous to the town, along with the 2 applicants that we thought could work with the town the most. And now we just put the decision in the planning board's hands when we're the elected officials, and that's the whole process that I thought we were following for the last year or 6 months or whatever, and I think all the applicants felt that way too.
So I guess now the question is,
clarify
are the
that?
applicants going to have to do this same whole thing again to planning so that two of them get
It's
it?
first come, first serve.
No.
First come, first come, first serve. So may I ask through you,
Yes.
caregiver, can I ask caregiver?
Yeah, that's Karen.
Can you get things ready to, even if you need to get more, can you get something to bring fast?
We've started the process, the traffic counts have been done. We're quite far ways along with the local engineer, but it depends on what form the planning board wants to accept an application. The DOT curb cut permit is the thing that could take the longest for application. The rest of the application could be ready within 30 days. But according to the special permit checklist that Gene has, you have to, I believe, have that DOT curb cut permit in hand before you can apply, unless a waiver would be granted for our application.
May I?
Tend to know like the rules.
Yeah, I'm going to ask Jean too, but I personally don't think that'll be too difficult. I mean, there is a curb cut there already.
It's a state process.
Yeah, Jean.
And the process has changed a little bit too. Now DOT is having the planning board do the site plan approval and then doing their final approval. So I would say it would be possible to get a waiver to that requirement.
Okay, question?
Chairman Superintendent, just one question with regard to the language that you just referred to on the special permit and the requirement of the Cannabis Control Commission. Does the special permit simply require that the applicant has submitted an application, or does it distinguish and say that they've received a provisional license from the commission?
Can you clarify?
Very two important distinguishing milestones.
Counsel, you might know that.
Yes, reading from the bylaw under application requirements, an application must contain copies of all licenses, permits, and documentation demonstrating application status, registration, or licensure by the Commonwealth of Massachusetts. It does not explicitly require that you have to have a provisional license to apply for a special permit.
So that theoretically could mean an applicant has simply submitted a complete application.
Yeah.
So that's not hard to do. That I can do that 10 minutes after we have the HCA. So I think that puts us back in the same position.
Okay, anything else from the board? Was that said vigorously or just?
No, that was the motion.
Okay, is there a second? Any discussion?
I was going to second it.
Oh,
Okay.
I could hear you. Any discussion? All in favor? Okay.
I think I'm ultimately going to
Well,
And the choosers, has that always occurred? Is that how?
thank you for the water.
They come to.
I'm gonna have some dark red stuff at home.
This is totally
I'm just trying
different.